The Federal High Court in Benin City on Thursday adjourned the case for hearing involving the removal of His Royal Majesty Dr. George Oshiapi Agabo, the Okumagbe of Uwanno Kingdom of Esako East Local Government Area by the Edo State Government to October 2nd, 2025. The adjournment follows the absence of the defendants and the request by the State Government Council for more time to study the case.
On the 30th of April 2025, Dr. George Oshiapi Agabo, the Okumagbe of Uwanno Kingdom in Esako East Local Government Area, was allegedly removed by the Edo State Government as the traditional ruler of the community, prompting him to approach the Federal High Court citing unlawful removal. At the resumption of hearing on Thursday at the Federal High Court 4, the State and Claimant Council were present, but the defendants in the case, including the Attorney General and Commissioner for Justice, Commissioner for Local Government and Chieftaincy Affairs, and Commissioner of Police, were absent. The State Council submitted a counter affidavit, and the Claimant Council, Claimant Uwanno, SAN, responded to the counter affidavit. However, the State Council requested an adjournment to review the affidavit, which prompted the Claimant Council to question the absence of the third and fourth defendant. The Claimant Council, Claimant Uwanno, SAN, urged the court to expedite the case and prayed that status quo should remain and that Dr. George Oshiapi Agabo should remain as the traditional ruler of Uwanno Kingdom until the defendant appear and judgment is passed, arguing that his removal was unlawful due to lack of fair hearing. The court, however, granted the State Council request for additional time to review the document and adjourned the case for hearing to October 2nd, 2025. Citing the need for all parties to be present. In an interview with journalists, the counsel to the Claimant Uwanno, SAN, commented on the adjournment of hearing and expressed optimism for a smooth hearing at the next sitting.
We were ready to go on, but the state served us what we call counter affidavit just this morning. But because we were prepared for this case, we had to do everything we could to respond to those two counter affidavits. And I'm pleased to inform you that we responded to those counter affidavits when we served. We had to go back, and that's why this matter couldn't go on as early as 9 o'clock that we're supposed to have started. So that is what happened, and we told the court we're ready to go on. But the state wanted an adjournment that they needed to see, to look at what we have deposed to in our further affidavit, and we opposed it that no, you were supposed to have served us these processes a long time ago, but you did not. And now you served and we responded that the matter was set for hearing. But you could see what the court was looking at, that we needed to carry everybody along, and that the third and fourth defendants were not in court, and that you wanted particularly the CP that extracted an undertaking from the claimant to be in court. But on the second time, when she looked at the undertaking as we exhibited, she now discovered that it wasn't the CP that actually extracted that undertaking, but one of his officers, or even though he was copied. And it was very clear, our position before this court this morning is very clear, that the law being relied upon by the State Executive Council in suspending or removing the claimant as the Okumagbe of Uwanno Kingdom, a throne he had occupied for the past 23 years without a hearing, cannot stand in the face of our Constitution. That Section 36 of our Constitution, if you make any allegation of crime against anybody, or any allegation at all against anybody, that before you take any action against him, you must offer him an opportunity to be heard. In this case, Okumagbe was not asked any question. Okumagbe was not queried by anybody. Nobody alleged anything against him. But the state is saying that under Section 28 of the Traditional Rulers Edict of 1979, made by the military, that they could remove any traditional ruler without any inquiry, without any investigation, without granting the person fair hearing. That is what we have told the court this morning, that that law cannot stand on the face of our Constitution, that law is antiquated, that law was meant for the military, and the military had long gone, and that a progressive state like Edo State shouldn't be seen projecting that kind of law when we're not in a banana republic, that there is no justification whatsoever under a democracy that a state government should say they can take any action, take any adverse action against anyone without granting that person at least fair hearing.
Meanwhile, comment could not be obtained from the State Council as she left immediately after the adjournment to October 2nd, 2025. Sarogie Agwebo reporting for BTV News.